Alright, so this next video might be a little off topic, but in terms of genocide and such, and the stages and or how it as a genocide expresses itself, this is pretty important. So the ICWA, the Indian Child Welfare Act, which the Supreme Court was thinking of actually attacking this year, I believe. Um, so let's read about what that is first. About the ICWA. The Indian Child Welfare Act was enacted in 1978 in response to a crisis affecting American Indian and Alaska Native children, families, and vibes. Studies revealed that large numbers of Native children were being separated from their parents, extended families, and communities by state child welfare and private adoption agencies. In fact, research found that 25% to 35% of all Native children were being removed. Of these, 85% were placed outside of their families and communities, even when fit and willing relatives were available. Congressional testimony documented the devastating impact this was having upon Native American families and tribes. The intent of Congress under ICWA was to, quote, protect the best interests of Indian children and to promote the stability and security of Indian tribes and families, end quote. So, again, even though this is not like a gendered side thing, I think you could say that Native American people would probably be discriminated against for having like a third gender. Like, they, like, uh, non-colonizers, indigenous people, that's the word, they were sort of the initial people who did non-binary, you know. Obviously, everybody had the potential in their own group to have a non-binary or whatever person in there, but even a colonizer could have had a non-binary, but that's not the point. Um, okay. Oh, it also was a functionality thing in tribal society to have a third gender, as you know, as we read in the destruction of the extermination of the Joyas. I assume other cultures had this sort of like intermediate of the balance type of thing going on. All right, sorry about that. Congressional testimony documented the devastating impact this was having upon Native children, families, and tribes. The intent of Congress under the ICWA was to, quote, protect the best interests of Indian children to promote the stability and security of Indian tribes and families. ICWA sets federal requirements that apply to state children custody proceedings involving an Indian child who is a member of the eligible for membership in a federally recognized tribe. At the time, not only was ICWA vitally needed, but it was crafted to address some of the most long-standing and egregious removal practices specifically targeting Native children. Among its added protections for Native children, ICWA requires caseworkers to make several considerations when handling ICWA cases, including 1. Providing active efforts to the family, 2. Identifying a placement that fits under the ICWA preference provisions, 3. Notifying the child's tribe and the child's parents of the child custody proceedings, and 4. Working activity to involve the child's tribe and child's parents in the proceedings. Because these added protections address not only specific systems abuses directed at Native children, but also their unique political status and cultural considerations, ICWA has been labeled, quote, the gold standard of child welfare policy by experts and national leading child advocacy organizations far beyond Indian country. Specifically, the measures of ICWA to keep Native children in relative care whenever safe and possible has since then become the best practice in the wider field of child welfare and increasingly codified into state and federal law for the wider population. Although progress has been made as a result of the ICWA, out-of-home replacement still occurs more frequently for Native children than it does for the general population. In fact, recent research on systemic bias in the child welfare system yielded shocking results. Native families are 4 times more likely to have their children removed and replaced in foster care for their white counterparts than their white counterparts. So, in spite of the advances achieved since 1978, ICWA's protections are still needed. Well, what about the removal rate for African people and Latin people and Chinese people? I want to know that too. I mean, I think we kind of already know what the, what the prison industrial complex is sort of separating families as is, so that could be this version of that. Okay. Much of this need can be attributed to oh, wait, did I not read something? Oh, sorry, I read that. Much of this can be attributed to non-compliance with federal law itself. For most of its history, ICWA has lacked an official oversight agency at the federal level, a national data collection apparatus, and an enforcement authority. As a result, compliance with the law has been uneven at best. The 2013 U.S. Supreme Court decision, Adoptive Couple versus Baby Girl, highlighted the context of which Congress' original intent could be interrupted in widely disruptive ways. To address these uncertainties and improve implementations of ICWA, the Bureau of Indian Affairs, BIA, provided additional federal guidance, some of the first time since enactment of the law. In December 2016, the BIA published revised guidelines, enacted guidelines for state court and Indian child custody proceedings. These are non-legally binding and were the first revisions since 79. That same month, the first ever comprehensive federal regulations addressing ICWA implementations for state courts and public and private agencies became effective. These regulations provide clarifications of many of the key requirements under the ICWA and are legally binding. Additional information about the Indian Child Welfare Act can be found at our latest news page in ICWA of the Our Work section of our website. Okay, so with that being said, we'll get to the moment it was about to be taken out. I briefly mentioned this in a stupid garden video. I should have just made the actual video. Okay. What happens if the Indian Child Welfare Act is overturned? Throughout history, individuals and settlers have undermined and threatened indigenous people's livelihoods in what is now the United States. This includes multiple attempts to eradicate any traces of Native Americans or indigenous cultures. These attempts put Native American communities at risk. Circling Eagle Law can help explain what legal stipulations are in place to help protect indigenous peoples and their cultures and what may potentially be at stake. Assimilating cultures. When settlers initiated the seizing of indigenous land, there was also the forced separation of families. As children were forcibly removed from their homes and families, they were subsequently forced to assimilate into the settlers' norms and ideals of culture. This practice was extremely harmful as its attempts to eradicate native cultures and practices entirely. Without a future generation to eradicate, many indigenous communities faced a loss of their way of living and culture as a whole. Enter the Indian Child Welfare Act. In previous blogs, Circle Eagle Law has helped explain the Indian Child Welfare Act and its purpose. To briefly explain, this act was initially passed in 1978 with the purpose of helping protect indigenous children in the United States. Specifically, it targeted the forcible removal of Native American children from their homes and restricted the adoption process. When Congress passed this act, they wanted to uphold the best interests of those indigenous children, but also keep in mind the preservation and history of tribes. The importance of the ICWA. Before the ICWA, an alarming number of indigenous children were being wrongfully taken from their homes and placed into adoption agencies. It is estimated that anywhere from 25 to 35 children were removed from their homes, with most of those removed placed in non-native homes. Furthermore, it is important to underscore how harmful these removals can be to indigenous children. Well, yeah, dead genocide, guys. This is literally, yeah. Studies have demonstrated that the prolonged separation from tribes and cultures can severely harm a child's mental and physical well-being. This level of trauma crosses multiple generations and is an all too common experience since the ICWA was passed. Now, I imagine there's just generational trauma as is, so, like, this feels like a band-aid in comparison to what we've already done. I suppose there's, like, Native American comedians that sort of cope in a positive way, but it's still, like, demented atrocities are not just forgotten like that. Okay. Calling the ICWA into question. While it is easy to see the importance and necessity of the ICWA in preserving Native American traditions and protecting children, the Supreme Court has reviewed and called this act into question before. In November 2022, the Supreme Court reviewed Brackeen v. Harland, a lawsuit brought before the court by the state of Texas and other individual plaintiffs. The court claims that the ICWA is unconstitutional, that indigenous children should not have limitations on where they can be placed. In November 2022 hearing, the ICWA was critiqued and scrutinized by a couple who attempted to adopt an indigenous child but did so unsuccessfully. The young girl now lives in her tribal community and is learning her culture. This discussion comes at a time when in recent years the extent of abuse that occurred at Indian boarding schools is becoming more apparent, as well as the intergenerational impacts and traumas from the time. The Supreme Court is expected to reach the decision regarding the ICWA June 2023. It is not certain that they will uphold this act, which means that the Native American communities could face further scrutiny. So luckily, it didn't actually get touched. Ultimately, if the Supreme Court makes the decision to overturn the ICWA, states would regain the control to remove Native children from their families. This would put an overall existence and longevity of tribes at risk. It is vital to continue to support the ICWA and take action against the possible overturning of this protection for indigenous tribes or communities. Want to learn more? Okay, so this last one in this third bit, I believe is, you can say it's positive, but I got this, like, doomer pill, like, conspiracy theory about this, but positive. Okay. The Supreme Court leaves Indian Child Welfare Act intact. In a major victory for Native American rights, the U.S. Supreme Court on Thursday upheld key provisions of the Indian Child Welfare Act, a law enacted 45 years ago to remedy decades of past government abuse. Can you imagine? It's only been not even 50 years and they just wanted to, like, potentially strip it away. What is wrong with you guys? By a 7-2 vote, the court ruled that the law does not impersonally impose a federal mandate on traditionally state-regulated areas of power. Writing for the court majority, Justice Amy Coney Barrett pointed to 2 centuries of precedent that have established the broad congressional right to legislate on Indian affairs, including family law matters. Quote, "The Constitution does not erect a firewall around family law," end quote, she said. On the contrary, she wrote, "We have not hesitated to find conflicting state family law preempted by federal law." While the tone of Barrett's opinion was often technical, it is noteworthy that the 2 of her 7 children are adopted, as are Chief Justice John Roberts' children. Backgrounds on the 1978 law. The Indian Child Welfare Act, known as ICWA, was enacted in 1978 after the congressional investigation found that in 1950s, 60s, and 70s, over one-third of all Native Americans have been removed from their homes, some forcibly and some placed with non-Indian families and institutions with no ties to the tribes. To ensure that would never happen again, the law established 3 preferences for the placement of Native American children, where they were adopted or put in foster care. The first preference is for placement with the child's extended family, then to other members of the tribe, and if neither of those is available, to members of another tribe. Those preferences were challenged by the state of Texas and by non-Indian adoptive parents. They argued first that the law unconstitutionally supplemented the core functions states and their traditional roles in family law matters, and second, that the adoption preferences were unconstitutional racial classification. But on Thursday, the Supreme Court explicitly left the Indian Child Welfare Act law intact, prompting joy among Indian tribes. The court's decision, however, left one important question unresolved: whether the statute's system of preference for Native American parents amounts to an unconstitutional racial preference. Several non-Indian adoptive parents made that argument, but the court said that for procedural reasons they had no legal standing to bring their cases to the Supreme Court. Justice Brett Kavanaugh joined the Barrett opinion, but wrote separately to say that, in his view, the preference issues remains a, quote, serious one, end quote. Still, several Indian laws experts said today that it may well be difficult to find a suitable test case to bring to Supreme Court because most are settled without any appeal. Michigan State University law professor Kate Fort, who tracks these cases nationally, says that in the 6 years between 2015 and 2021, there were only 14 placement preferences appealed in the state courts. Quote, "Given that we have hundreds of child protection cases every year, that's a very small number," end quote, she said. Bertram Hirsch, who helped write the Indian Child Welfare Act back in the 1970s, adds that it is rare for an adoption case to last long enough to be a live dispute when it gets to the high court. It's going to be extraordinarily difficult, I think, to find a plaintiff who is willing not to proceed to finalization of an adoption and instead keep a child and their family in limbo through years of litigation with no resolution, he said. Indeed, all 3 of adoptions before the court today have been finalized, though one non-Indian couple, Chad and Jennifer Braggeen, is now trying to adopt a second Indian child. Matthew McGill, the lawyer who brought the ICWA challenge on their behalf, says he will pursue the race discrimination claim in state court adoption proceedings involving the second child, a 5-year-old girl who is the sister of the child the couple have already adopted. Despite the win for the Indian tribes on Thursday, Chief Hoskin is worried about other Indian preferences outside of adoptions, statuses that give special preferences for Indian gaming, Indian contracting, and Indian employment at the Bureau of Indian Affairs. Quote, "I'm always braced for the next challenge, particularly on equal protection grounds, because there's a whole lot of statuses out there that are specific to bringing justice and fairness to Indian countries," he said. So this is good for now, I guess. Like, it's up in the air what the next issue is going to be, and if this is going to come up again. Oh, there's more to this. Okay, good. Alright. Dissenting view. Dissenting from Thursday's ruling were Justice Clarence Thomas and Samuel Alito, who wrote separate dissenting opinions. Thomas' 40-page dissent argues that his long-held view that the Constitution's Indian protections do not extend beyond matters of trade and commerce. And Alito wrote that, in his view, Congress, quote, "does not have the power to sacrifice the best interests of vulnerable children to promote the interests of the tribes in maintaining membership," end quote. Wait, what? Does not have the power to you don't have the... What? You could just... They could care... I mean, wow. You could, honestly, just amend something in some way. Yes. Justice Neil Gorsuch, who has earned a reputation as the most knowledgeable justice on questions of in history and the most aggressive defender of Indian rights, joined Justice Barrett's majority decision in full, but wrote what was essentially a rebuttal to the dissenters. The mass removal of children from their family homes in the 1950s, 60s, and 70s, he wrote, quote, was only the latest iteration of much older policy of removing Indian children from their families, one intentionally spearheaded by federal officials with the aid of their state counterparts nearly 150 years ago. In all its many forms, the dissolution of the Indian family has had devastating effects on children and parents alike. It has also presented an existential threat to the continued vitality of the tribes, something many federal and state officials over the years saw as a feature, not a flaw. End quote. And goes on to say, in adopting the Indian Child Welfare Act, he concluded, Congress exercised its lawful authority to secure the right of Indian parents to raise their families as they please, the right of Indian children to grow in their culture, and the right of Indian communities to resist fading into the twilight of history. So, definitely a victory in terms of, like, anything, honestly. But this is basically juggling with other people's children, as we will see as what's happening in Florida. This is pretty terrible. So while there's victories for some native tribes, there's encroaching sort of demise for other people's children. Okay. Florida passes bill that allows for illegal kidnapping of transgender children. The bill would allow courts to intervene in custody disputes and remove trans children from gender-affirming parents. So this makes it out like it's like a custody dispute thing, but it's centered around trans kids. So it's not like it's an opinion that parents get to have. This is literally about them and taking them away. Alright. The Florida House of Representatives has approved a bill that would allow state courts to intervene in custody disputes and remove transgender children who are receiving gender-affirming care from supportive families with whom they live. In extreme circumstances, legal experts say that this may even mean, quote, involve the state taking physical custody of a child, end quote. SB 254 would classify gender-affirming care for transgender youth as a form of serious physical harm, which would be cited during a custody enforcement hearing to allow unsupportive parents to take, quote, physical custody of the child, end quote. The amended bill, which originally passed on April 4th by a vote of 27 to 14, now returns to the Senate. This law ensures death. It violates my parental rights, said Amir Roy Mulca, who is a parent of a trans child, speaker to the Tallahassee Democrat. The vote comes as the Florida legislature has also recently passed two other anti-LGBT bills, one targeting LGBTQ-friendly businesses and one prohibiting gender-inclusive bathrooms. Wow. Even in my environment at my work, I know for a fact it's pretty anti-LGBT. Like, there's so many comments that are so casual, but even they have a bathroom door for binary or non-binary, which is cool. You know, it's kind of random because I wouldn't think my boss would be like that. Alright. It is shameful that our Florida legislature continued to pass dangerous bills designed to silence, harm, and erase trans people in Florida, end quote. Cara Gross, the legislative director and senior policy counsel of the ACLU in Florida, said in a statement, quote, these bills directly threaten transgender Floridians, end quote, or fundamentally human rights and safety. The Florida legislature's insistence on targeting trans people is bizarre, unnecessary, unconstitutional, and extremely dangerous. Official, end quote. Sorry about that. While the most recent language of SB 254 no longer includes the horrific provisions that would have allowed Florida courts to modify out-of-state custody agreements, allowing unsupportive parents to move their child to Florida to prevent them from escaping gender-affirming health care. It still includes the, quote, trans-kidnapping provisions that would give courts emergency jurisdiction to remove trans children from their families because they are receiving gender-affirming care. So this doesn't go as far as the abortion trafficking bill, which I'm thinking they're working on it for this, but it's still not good. Like, seriously. Quote, I can't believe I'm writing this, said former Democrat Representative Carlos Guillermo Smith. Quote, parents would be charged with felonies and thrown in prison. This is fascist, end quote. The legislation would also prohibit the use of state funds for gender-affirming care, prohibits gender-affirming care for trans youth, and direct the State Board of Medicine to adopt emergency rules regarding trans youth who are already receiving gender-affirming care. Any healthcare practitioner who provides trans kids with gender-affirming care would be guilty of a felony under the legislation. Florida Senator Lori Berman D. condemned Republican attacks on bodily autonomy and trans health care in a comment before the chamber voted to pass the legislation. Quote, I would say free states don't ban health care, Berman said. The bill is wrong on the way it attacks transgender adults, wrong in the way it attacks parents' rights to raise their children, and wrong on how it puts medical professionals at risk, end quote. In March, the Florida Board of Medicine enacted a rule that banning gender-affirming care for transgender youth who had not yet started puberty blockers or hormone therapy, making it the 8th state to restrict gender-affirming care for trans youth. Under the rule, healthcare practitioners could have complaints filed against them. It found to be in violation of the rule, practitioners could face fines, suspension of their license, and other consequences. The rule is currently being contested by the Southern Legal Council and national advocacy groups in court. SB 254 would circumvent this law by legislating the gender-affirming healthcare ban for trans youth into law. Quote, this law will cause massive upheaval in medical care for the transgender community and cause immediate harm to thousands of Floridians of all ages who will lose access to life-saving medical care, end quote, the ACLU said in a statement. Alright, as we see and as I've said, juggling with different people's children. You give some rights to some, and you take away others, and you just, obviously, this is certainly a crumbling democracy. Alright, guys. I'm happy for the victories.